Workers on Wednesday. Workers on Wednesday. But of course, this part of the show is dedicated to everything that has to do with labor relations. This show comes in to increase knowledge and understanding of recent trends and issues concerning labor relations. And today is no different. We're unpacking the Labor Act and its dictates to try and further understand exactly what is happening in that area. Parliament has passed the Labor Amendment Bill. And so many things that are coming by because of those amendments, and we want to understand further. But you can also come through on 0719-100404 and be part of that show. Remember, we're also live on our Facebook page at Capital FM, so you can log on to watch what's happening in studio. And of course, even later on as well, you will still find the video on our Facebook page. Joining me to dig deeper and further into this amendment is Advocate Richard Masenire. Good morning to you, Advocate. Thank you so much for joining us.
Good morning. Thank you for having me.
Awesome. So we understand this Labour Amendment Bill has now been passed into law. Perhaps to break the ice on this conversation, a brief explanation on what then that means when a bill is now passed into law.
When a bill becomes law, it means it becomes the reigning law that applies. It replaces everything that was there before, and it becomes the current law that must be applied.
Interesting. Perhaps it would be prudent to look at some of the things that were existent when it was still a bill before. What was some of the dictates that were the core principles of the bill?
Thank you very much. When it was a bill, the Labour Act then, in terms of dispute resolution architecture, it provided for resolution of disputes in various provisions. It provided for negotiations by workers' committees at shop floor level, where they can actually conclude a collective bargaining agreement. But mind you, I emphasize that would be at shop floor, because I'm aware that there can be negotiations at industry level. So Section 24 and 25 provide for negotiations between workers and employers at shop floor, and they can conclude a collective bargaining agreement which resolves any disputes that may be between them, but may be particular to their organization or their company. But at industry level, Section 74 provide for collective bargaining, that is a forum for negotiation, resolving disputes at industry level between trade unions and employers' organizations, so that they can also iron out any disputes or any alleged unfair labor practices. And take note that the CBA that would have been concluded under Section 24 and 25 would have to be acceded to by the collective bargaining agreement forum at industry level. So where workers negotiate with their particular employer at shop floor, they then have to pass that agreement to the industry level for ascension, for confirmation. So that is one approach before the bill came, through which resolutions of disputes were settled. But the Labour Act provides for conciliation as one form of dispute resolution under Section 93. And there the labor officer is the person that has the powers and responsibility to resolve disputes or unfair labor practice. So in the event where there is a dispute between employer and employees, they could take their dispute or unfair labor practice to a labor officer, who would then conduct a conciliation in terms of Section 93. And during that era, that is before this amendment comes into effect, the labor officer would then draft a ruling that was called a draft ruling, which was not binding. You would have to have it confirmed by the labor court before it becomes binding. That is what was reigning then. So we also happen to have Section 63 that also provides for dispute resolution, but through designated agents. These are officers that are appointed to resolve disputes at National Employment Council level. So within an industry, DAs, designated agents, are appointed. They resolve disputes in that industry. And they would come up with what is called a determination, which was a binding, as opposed to the draft ruling of the labor officer.
So, dispute resolution.
Yes, that is one way of resolving disputes between employers and employees. But and then after all those two available is also the route where arbitration could be employed to resolve disputes. So you would understand that arbitration would be a higher level of dispute resolution after the earlier methods have failed to yield any positive results. So those were basically the avenues through which disputes could be attended to and resolved.
So with that said, what are the changes now that have happened? I understand kuti nyaya draft rulings was repealed and zvimwe zvakasiyana siyana, terminations I also understand kuti they were maintained. What are some of the things that have changed now since it's now law?
Right, thank you very much. What has changed now relates to the powers the labor officer has in terms of section 93. In the previous era, before the amendment, he would issue a draft ruling, like I said before, that would require confirmation, meaning to say it had no power on its own. It had to be confirmed by the court. That has now been repealed by the current amendment. What then would happen from now onwards after the amendment is that when a labor officer carries out conciliation over a dispute or an unfair labor practice between the parties, he issues a certificate of settlement that is provided the parties have agreed to settle. What is key in terms of change there is that the certificate of settlement is now different from the one that he issued before the amendment. It is now having the status of a civil judgment, which means it is now more powerful. It is registrable with a relevant court depending on jurisdiction in terms of monetary limits. So when it is issued, it's different now from the previous where it had no power. But this time around, moment he issues a certificate of settlement, it is as good as a judgment that has been given by a civil court. So it is quite binding, which is a very positive development because it sort of expedites the resolution of disputes between employees and employers. You see, the previous route would take quite some time. You imagine he does a draft ruling, it doesn't bind, he approaches the court for confirmation. That is a whole lot of a long time. And the dispute will be outstanding. So that's the major change as regards a conciliation before a labor officer.
So as it stands, NEMA changes are repo Wamasinire.
Yeah.
What does it do for the employee in terms of perhaps the status now in terms of the advantages that they might have and the protection that comes through Nekuda kwe labor law?
Yeah, like I said earlier, the process is now expedited. It's faster than it was before. When a person has got a dispute, sometimes the dispute involves him being away from the workplace. So if that resolution takes long, it means the person also takes long outside the workplace. So being faster, it means it is to the advantage of the employee. The settlement becomes a civil judgment right away, which means it becomes binding on the parties. That's quite an advantage to the employees. Yeah.
Interesting. I also understand kuti panokwanisa kunge pane dzimwe nyaya dzadziri kutozama kugadziriswa panguva inoi pazochinjwawo mutemo wacho kuti uchiita law. What happens to the cases which were already being determined pachishandiswa mutemo wakare?
Right, they are transition arrangements that have been provided and under section 128 of the amendment, where if currently as we speak and when the amendment becomes law, labor officers were having draft rulings that were due for confirmation by the labor court in terms of the previous law. That provision, section 128, provides that they instantly become civil judgments, which means there will be no need for them to be registered with the labor court as it was before. So they automatically become civil judgments, which means the implementation is automatic. The change is automatic. If you are having a draft ruling that you were wishing to register, automatically it becomes a civil judgment, which means it takes effect and it becomes binding.
Interesting.
Yeah.
I also then understand, Kuti, within the new law, I think these are some of the things that ordinarily people would want to hear about. Things like the removal of the clause allowing termination of job contracts on notice. What does it also mean to workers when it comes to their job contracts?
Right. It means security of tenure. When you get employed, you are a bit more secure, because the contract can not easily be vitiated by any conduct of the employer. So that it means more protection. The amendment has brought up protection to the employees. It is unlike in the previous dispensation, where willingly employers could just terminate the employment contract. So at least they've been afforded some kind of protection. Yeah.
Just going back a little bit, when you spoke about what was happening in the old system, what are some of the things that were perhaps slowing down the progress in terms of how these disputes were being resolved?
Well, like I said, the nature of the outlined processes themselves inherently slowed the process, because stages were to be complied with. You go to attend conciliation, a certificate of settlement a draft ruling has to be made, it has to be registered. So inherently the structure of the resolution mechanism slowed the process. Yeah.
You spoke about shop floor level as well as industrial level.
Yeah.
Is that another phase where also things might have been slowed down in terms of then progressing to the next level?
No. Those negotiations at shop floor level and at industry level have not been removed. They remain as avenues for other dispute resolution approaches. Remember, before a dispute goes out of an organization or a company, there must be internal processes or internal remedies that must be resorted to. So negotiations at shop floor, in terms of section 24 and 25, they remain. They are still available to the two parties, the two social partners, the employees and the employers. And at industry level, it still remains. It still remains. The changes have happened where the dispute goes out of the organization to a labor officer under the Ministry of Labor.
Interesting, quite interesting. 27 after 9 on Capi Talk 100.4 FM, Marais Heartbeat. And of course, we are discussing the new labor law and its amendments, and of course, the expected changes to the dispute resolution mechanisms as well. Feel free to come through on 0719 100404. We'll take a short breather. When we come back, we continue with our conversation. Stay with us.
If yesterday didn't work out, we try again today. Capital 100.4 FM. Harare's heartbeat. Tune into the life-changing radio, Capital 100.4 FM. Harare's heartbeat. Radio for you and your family. Capital 100.4 FM. Harare's heartbeat.
Ndichatiwe iwewe unosvike piko uchingotisa mumvuri wako, vakaiteiko vanozvidzivitsa pachavo, unenge usati wada kure kwegava kuna chiriko wanzwa kana wafunga kupinda munzira isidambe, rudo moto usatsima usareka, usakanganwa isamuna mato zvisabude nepamwe, rekodo neshanje pavachange vorwisa. Iwewe ndichati iwewe handichada kunzwa pauchandiudza uchada tatova nyama imwe wave kutoziva zvandinoda handinete ndivimbise haunetiwo kunyangwe uvete vachabvunza ndoti ndoda iwe handinete ndivimbise haunetiwo kunyangwe uvete vachabvunza ndoti ndoda iwe kana wafunga kupinda munzira isidambe rudo moto usadzima usareka usakanganwe isamuna mato zvisabude nepamwe rekodo neshanje baba change vorwisa iwewe ndichati iwewe ndichati iwewe iwewe ndichati iwewe ndichati iwewe kana wafunga kupinda munzira risidambe rudo moto usadzima usareka usakanganwe isamuna mato zvisabude nepamwe rekodo neshanje baba change vorwisa.
If yesterday didn't work out, we try again today. Capital 100.4 FM, Harare's heartbeat. Follow us on Twitter, Facebook, Instagram, and YouTube at Capital FM, Harare's heartbeat. If yesterday didn't work out, we try again today. Capital 100.4 FM, Harare's heartbeat.
20 minutes before we get to 10 right here on Capital Talk 100.4 FM, Harare's heartbeat. And of course, this is the first hour of the Capital Crunch, and it is Workers on Wednesday, talking about the new labor law and its dictates as well. Maybe just to take you back, Advocate Masinire, on the idea of arbitration, maybe if you could just perhaps explain it a bit further for us in terms of the two parties and what is involved there.
Right, where for arbitration as a dispute resolution mechanism, it comes on when one party may not be happy with a ruling or an order as given to conciliation, or even when they do not agree at all, in which case a certificate of no settlement is issued. In that circumstance, parties themselves may opt to have the matter referred to arbitration, or if they are engaged in an